Hello, my name is Raquel Brízida Castro. I'm a professor in the Faculty of Law, University of Lisbon. I'm an integrated effective researcher at Lisbon Public Law Center, and I'm also a lawyer. The title of my article is Ethics versus Law in the Regulation of Artificial Intelligence, Ethics à la carte. Well, this article is based on my Portuguese monograph, Constitutional Law, Technology and Cyberspace, Decline of Constitutionalism in the European Union. Well, this book is currently in print by Almedina. Despite European legislators' attempt to regulate the artificial intelligence systems, the option for risk-based regulation dispenses the prior intervention of the regulator, stricto sensu, exacerbating the relevance of alternative regulatory instruments. In fact, in addition to the traditional sources of regulatory law, which will focus more or less directly on the systems that are potentially most dangerous to fundamental rights, it is important to note that the current approaches to regulate artificial intelligence are predominantly based on soft law instruments, the drafting of codes of ethics and conduct, and the use of rules that are in principle not legally binding, namely technological standards and harmonization rules. In the European Union, a legal approach to artificial intelligence based on fundamental rights is based on the European Union treaties, the Charter of Fundamental Rights of the European Union, and international human rights law. However, in a risk-based regulatory model, such as one the European Union has outlined, regulation through ethics and codes of conduct is particularly important. From an international human rights law perspective, the doctrine notes that it is possible to identify a common international legal ethical standard applicable to artificial intelligence. Well, the main United Nations human rights treaties have been signed and ratified by around 170 states. Experts distinguish between obligations to respect, to protect, and to fulfill. The obligation to respect requires states not to violate established human rights standards, this being a negative obligation that restricts the abuse of government power. The obligation to protect, on the other hand, is positive and covers the duty of states to adopt legislative measures to prevent third parties from violating or adversely affecting the enjoyment of rights by others. The obligation to fulfill is a positive obligation for states to adopt broader human rights protection policies. Governments, in turn, impose legal and extra-legal obligations on private actors. A shared social commitment to universal human rights and related goals, including sustainable development, facilitates a culture of respect for fundamental rights. It is said that it can be sanctioned by law, but that it is ethical in nature. The United Nations Guiding Principles on Business and Human Rights, unanimously adopted by Human Rights Council, requires companies to carry out human rights due diligence assessments of their business activities. A draft United Nations treaty and the proposal for a directive of the European Parliament and of the Council on corporate sustainability due diligence are currently being negotiated. Human rights due diligence refers to the process or set of measures adopted by a company with a view to identify, prevent, mitigate, stop, and minimize the negative effects, potential or real, of its operations and the value chains in which it operates on human rights and the environment. These legal instruments impose a formal procedural obligation on companies to take stock prior to their activities of possible adverse impacts on human rights. George Ulrich suggests that a similar formal requirement, human rights due diligence, should be extended to all artificial intelligence applications, whether public, private, or mixed, which would consolidate what he calls amorphous field of ethicals, artificial intelligence guidance regulation, and will render the latter consistent with the existing normative framework regulating public administration and private enterprises. Numerous technological processes and methodologies are currently being implemented to identify and assess the ethical risks of the respective artificial intelligence systems, as well to establish ethical principles that make them friends of society. Well, In any approach to fundamental rights, the roles of ethics in law in the governance and regulation of artificial intelligence stand out. Giovanni Sartor notes that artificial intelligence ethics in law are intended to provide normative guidance, proposing rules and values to govern human action and determine the constraints, structures, and functions of artificial intelligence enable socio-technical systems. However, although their respective demands can and should converge, the opposite can happen. For Sartre, human rights provide an important connecting factor between morality and law because they are stated as primary ethical demands and as opportunities, which include negative freedoms and positive freedoms. Fundamental rights are therefore rights of a moral and legal nature, as follows from the 2019 Ethical Guidelines for Trustworthy Artificial Intelligence. Trustworthy artificial intelligence should, in accordance with these guidelines, be 1. Lawful, respecting all applicable laws and regulations. 2. Ethical, respecting ethical principles and values. 3. Robust, both from a technical perspective, while taking into account its social environment. In this sense, as well as being rights that can be protected by the courts, fundamental rights must also be understood as universal rights based on the inherent moral status of human beings, and in this respect, they are also subject to artificial intelligence ethics concerning ethical norms that, although not necessarily legally binding, are crucial to ensuring reliability. According to the aforementioned guidelines, there are 4 ethical principles that should be respected by artificial intelligence systems, ethical imperatives that professionals in this field should always endeavor to uphold: respect for human autonomy, prevention of harm, fairness and explainability. Notwithstanding the above, especially in an attempt at the legal constitutional approach, it is necessary to explore the legal dimension of human rights, not least because there are important aspects of human rights of an ethical nature that are recognized in binding international, regional, and national legal instruments, creating legal obligations for states and other actors. Although there may be a significant intersection between different constructions of legal rights and ethical rights, the 2 dimensions cannot be confused. Certain ethical aspects of human rights may not be legally positivized, and this can be either correct or incorrect. The law incorrectly does not adequately implement the ethical standard it is supposed to implement, or the law correctly does not reinforce the aspects of ethics that it believes should be left to voluntary initiative. Nevertheless, Sartor makes us notice that ethics and law can influence each other because ethical political arguments can be used to argue that an ethical right or aspects or implication of it should or should not be recognized by the law and that the law should change accordingly, or support the interpretation, construction of sources of law, helping to determine how the law is applied. In turn, ethics can learn from the law through its institutional approaches to normative issues, its expression in sources, and the examples of how such sources are applied to concrete cases. Floridi insists on the need to comply with the entire normative map, not only digital governance, but also digital ethics and digital regulation. And he distinguishes digital ethics as hard ethics and soft ethics. Hard ethics corresponds to what shapes the law. It's what we usually think of when discussing values, rights, and duties, and more broadly, what is morally right or wrong, and what should or shouldn't be done through new regulations or changing existing ones. Soft ethics, on the other hand, encompasses the same normative foundation, but, says Floridi, but it does so by considering what ought and ought not to be done over and above the existing regulation, not against it or despite its scope, or to change it or to bypass it in terms of self-regulation. In other words, soft ethics is post-compliance ethics In this case, hot implies may. You can read this soft ethics and the governance of digital. The word ethics comes from the ancient Greek words ethikos and ethos, referring to character and moral nature. Morality, on the other hand, comes from the Latin moralis, meaning manners, character, and appropriate behavior. Both refer to the study of good and bad character, appropriate behavior, and virtue. Morality is often associated with etiquette and the rules of appropriate social behavior, while ethics has a more personal connotation pertaining to the cultivation of individual virtue abstracted from society. If we adopt a broad concept of morals, we can focus on the domain of values, an evaluative mode of inquiry which is distinguishable from scientific or descriptive modes of inquiry, which focus on facts. Well, this is the favorite domain of moral philosophers. In moral decision-making process, it is possible to adopt a script and the decision will be morally good if its outcome is good. A good moral decision is likely to involve all moral theories and generally takes the following points into account. First, all the facts surrounding the situation, taking into account the interests of all parties involved, and two, the moral principles involved and how they will affect all others involved. From the combination of these topics, it follows that there must be rationality and impartiality in every moral decision, something that will be guaranteed according to moral and ethical theories through the following four means. We can read in Joseph Kisa, Ethics in Computing, a Concise Model from Springer. Well, first, the use of the rational intuition of moral principles, which help us perceive moral principles such as the notion of justice and deciding what is good. Second, the use of reason to determine the best way to achieve the highest moral good. Third, the ability to distinguish between primary and secondary moral principles. Fourth, the rational calculation of the consequences of our actions. The calculation should tell us whether the reaction is good or bad, depending on the consequences. In the ethical approach to an issue, you start by saying what ethics is not. Well, ethics is not science, not the same as feelings. Ethics is not religion. It is not following the law or culturally accepted norms. When confronted with the law, however, some of the arguments put forward in favor of preferring an ethical decision are really questionable, because recourse to ethics cannot be seen as an alternative to the law. It is true that the legislator has some difficulty regulating certain material areas and is sometimes slow in approaching them. However, it is not advisable to base recourse to ethics on unusual prejudice about the legislator, such as a good system of law does incorporate many ethical standards, but law can deviate from what is ethical. Law can become ethically corrupt, a function of power alone and designed to serve the interests of narrow groups. You can read this at the Introduction to a Framework for Ethical Decision-Making from Markula Center for Applied Ethics. In this respect, we are forced to question where these same alleged defects are not likely to contaminate ethical decision-makers, undermining fundamental values of the democratic rule of law, namely legal certainty. This is, however, an empty, innocuous, and pointless debate because law and ethics much complement each other, even when it comes to regulating artificial intelligence. We find impressive the argument that ethical principles are too abstract and subjective to be the sole basis for effective regulation of artificial intelligence, even in the context of opting for risk regulation, as is the case with the European Union's proposal for an artificial intelligence regulation. Well, some authors have compared the most prominent principles contained in several codes of ethics drawn up to regulate artificial intelligence and found some consensus on 8 issues: privacy, accountability, safety and security, transparency, and explainability. fairness and non-discrimination, human control of technology, professional responsibility, and promotion of human values. Despite some similarities, the authors detected important difference in their interpretation, perhaps stimulated by the plurality of ethics that can justify or guide a particular behavior or choice. Here are several approaches that can be elected. Which option will produce the most good and do the less harm? This is the utilitarian approach. Which option best respects the rights of all who have a stake? This is the rights approach. Which option treats people equally or proportionately? The justice approach. Which option best serves the community as a whole, not just some members? The common good approach. Which option leads me to act as a sort of person I want to be? And this is the virtue approach. Well, in an exclusive recourse to ethics, any of the options listed is likely to lead us to a unipolar theory of fundamental rights, which overrides interpreters' philosophical and moral pre-understandings and preconceptions. This is a methodological option that leads to an undesirable functionalization of fundamental rights and exacerbates the dangers and hermeneutic excesses of certain pre-understandings and suprapositive conceptions of the Constitution and of the legal system, which have proved to be unhelpful in constitutional interpretation, precisely in the areas where such conceptions will be most expected. Entrusting the regulation of artificial intelligence exclusively to ethics leads to the legitimation of constitutional interpretation and fundamental rights in a nutshell, through ethics à la carte, which turns ethical experts into a kind of oracle, absolutely detached from any democratic and pluralistic radical, I will repeat. Entrusting the regulation of artificial intelligence exclusively to ethics leads to the legitimation of constitutional interpretations and fundamental rights in a nutshell, through ethics à la carte, which turns ethical experts into a kind of oracle, absolutely detached from any democratic and pluralistic radical, favoring abominable arbitrariness and subjectivity in their decisions. In fact, the key questions of artificial intelligence in a democracy must be the following, those formulated by Nemitz in Constitutional Democracy and Technology in the Age of Artificial Intelligence. Which of the challenge of artificial intelligence can be safely and with good conscience left to ethics, and which challenge of artificial intelligence need to be addressed by rules which are enforceable and encompass the legitimacy of democratic process, thus laws. The regulation of artificial intelligence involves weighing up fundamental rights, the interpretation of which brings us back to classic constitutional hermeneutic dilemmas. One of the difficulties of the traditional theory of interpretation is revealed precisely in cases where the Constitution does not contain an unequivocal criterion. This means in all situations that presuppose constitutional interpretation because the constituting power choose not to adopt it. What's more, not even the methods of interpretation can provide sufficient guidance should the meaning of words be discovered using specialized legal language or ordinary language, or according to the function the concept fulfills in each case. Systematic interpretation itself depends on whether it takes into account the place of law or connections of a material nature, and teleological interpretation can practically be considered an undesirable carte blanche. The process of relationship, coordination, and valuation of points of view and considerations leading to the solution of problems lies with the principles of constitutional interpretation, the principles of unity of the Constitution and of practical agreement, and the criteria of functional correctness and integrative effectiveness. The search for the unity of the Constitution, even in compromisarian constitutions, postulates the overcoming of the so-called contradictions of principles. In some cases, through the appropriated reduction of scope and part-to-part concessions, and in other cases, through the preference of or priority of some of the principles over others. Well, the American lesson by Lawrence Tribe on ways not to read the Constitution and the identification of two types of undesirable interpretative results, such as disintegration and hyperintegration, are suggestive. Disintegration is a form of interpretation that ignores the fact that its parts are integrated into a whole, effectively being a constitution and not simple sets of separate clauses and precepts with distant stories. And in turn, hyperintegration is the fallacy of treating the constitutional as a kind of seamless web, a brooding omnipresence that speaks to us with a simple, sacred voice, expressing a unitary vision of an ideal political society. Well, and this is an approach that ignores the fact that the whole comprises distinct parts that were introduced at different times in constitutional history, supported and refuted by different groups, or that reflect completely different, and in some cases, even opposite positions. Well, it is therefore illegitimate a constitutional interpretation that ignores its contradictions and inconsistencies, or that is based on the claim that all constitutional values can be immune to their contingencies. An increased risk erodes the hermeneutic legitimacy of the interpreter, who gives precedence to his philosophical, political, and moral pre-understandings in the exercise of his alleged free ethical choice. Ethics has assumed very importance in the regulatory attempts of artificial intelligence, equally in the current artificial intelligence regulation proposal. Article 69 of the European Union proposal provides that the Commission and the Member States should encourage and facilitate the development of codes of conduct to promote the voluntary application of the requirements set out in Title 3, Chapter 2, artificial intelligence systems other than high-risk systems. With regard to high-risk artificial intelligence systems, the proposed model is is risk regulation, dare to be designed to mitigate risks. Nevertheless, it is worth reiterating the evidence that ethics and laws are not functionally equivalent. So the codes of ethics or codes of conduct do not replace binding legal rules or their institutional means of control. Sartre cautions that ethical claims should not be directly converted into legal claims, nor should ethical claims be rejected because they are not accepted by positive law. The relationship of ethics with law, specifically in the context of artificial intelligence, precludes both ethics washing and ethics bashing. Compliance with ethics does not guarantee compliance with the law, but this also does not justify the devaluation of the role that it can play in the regulation of artificial intelligence, says Bietti in an article called From Ethics Washing to Ethics Bashing, a Moral Philosophy View on Tech Ethics. On one hand, when generally used in support of the regulation or self-regulation, it is in this precise context that ethics should be seen and not as a formal regulatory instrument capable of masking behaviors legally only apparently ethical. Ethical behavior is precisely ethical behavior and not necessarily law-abiding behavior. This is the only legitimate expectation to place in the performance of ethics and not any other. Which means that if a certain regulation is based on ethics, the only possible expectation is that the conduct of the regulated is an ethical conduct and not a conduct in accordance with the law and all its legal normative parameters, not least because theoretically, ultimately, there may be behaviors justified according to a certain ethical perspective, which may conflict with law. On the other hand, if the requirement is only that the conduct conforms to ethics, it is not legitimate to affirm that this same conduct is apparently ethical in a pejorative sense, just because it is not in accordance with the law. Well, so it's the end of my article. Thank you so much for all your attention.